Hello and welcome to Beacon Pointe's Fiduciary Point of View webinar series. This is our first webinar of many planned for 2019. Just as a quick introduction, I'm Doug Eagle, the Director of Retirement Plan Services at Beacon Pointe Advisors. And Beacon Pointe is a registered investment advisory firm located in Newport Beach, California that currently manages over $9.5 billion in assets. We'll be hosting a new Fiduciary Point of View webinar every 4 weeks on various topics pertaining to the defined contribution industry in both the for-profit 401k space as well as the not-for-profit 403b space. And our goal is to bring to light various topics for both our clients as well as the general plan sponsor community and bring in experts in their respective fields to help educate and inform all those in attendance. Our topics will discuss various areas such as how to choose and monitor your target date funds, new trends in the 403b space, as well as common compliance issues discovered during plan audits. With the start of a new year, many are looking to make New Year's resolutions, be it go to the gym, eat healthier, or look for ways to stay ahead. And today we're going to cover some of the hot topics for plan sponsors to be aware of for the new year and how to stay ahead of and prepare for some potential issues for the upcoming year. Think of it as pre-planning for your resolutions for the remainder of the year. The topics covered today, everyone will be able to relate to from a plan sponsor perspective, as well as from a personal perspective. The issues discussed today can affect all types of companies ranging in various sizes and industries, for-profit to not-for-profit organizations. We're very excited to introduce our speaker joining us today, Sherry Boutwell. Sherry is a partner at Boutwell Fay, located right here in our backyard of Newport Beach, California. Sherry is focused on the areas of employee benefits law and ERISA with an emphasis on retirement and deferred compensation plans for over 30 years. Sherry has extensive experience representing clients before the Internal Revenue Service, the DOL, the Pension Benefit Guaranty Corporation, and the United States District Court with respect to employee benefits issues. Sherry earned her JD from UCLA and her BA from the University of California, Irvine, and she is a member of the State Bar of California. She's also active in the Western Pension and Benefits Council Orange County and Denver chapters, and she's a highly sought speaker and writer on various employee benefits topics. I've also had the pleasure of working with her on several occasions and can say firsthand Sherry has a very practical and down-to-earth method of dealing with her difficult client issues. We have a lot to cover this morning, so with that said, I'd like to turn it over to Sherry.
Thanks, Doug. Happy to have you all here today for hot topics for 401k plan sponsors in 2019. Our firm works primarily with plan sponsors, and so I made a little list of the types of topics that our clients have been reaching out to us about, things we're getting questions about, that there's a lot of interest in as we start a new year. With that being said, so this is not legal advice, but they are hot topics. Hot topics. And here are the 3 topics I wanted to cover. First, using a 401k plan to help your employees pay off student loan debt. Second, cybersecurity issues for employee benefit plans. And finally, financial wellness initiatives. Let's start with using a 401k for student loan purposes. There's currently $1.5 trillion owed in this country on student loans, second only to mortgages. And there's a lot of interest by employers and now by Congress in finding ways to help student debt be paid and have retirement savings at the same time. A number of employees find that they just cannot contribute to their retirement plan because they're busy trying to pay off those student loans. So in August of last year, Abbott Laboratories obtained a private letter ruling from the Internal Revenue Service. We are going to talk in detail about that. There's also more of an informal approach, which is not necessarily recommended. That is, people pull out their retirement plan money to pay off student loans or borrow from the retirement plan to pay off student loans. That's one approach, maybe not the best approach financially for employees. And then late in December, there was the Retirement Parity for Student Loans Act introduced into Congress. So we can talk about that too. So what did this private letter ruling say and do? The Abbott Laboratories plan design allowed students to either contribute money to their 401k plan and get a match, or they could pay off student loan debt and get an employer contribution equivalent to what they would have gotten as a match had they made an elective deferral. And in this situation, there was a concern that setting up a plan designed that way would violate the Internal Revenue Code's rule that says you cannot make a benefit contingent on an employee making an elective deferral in a 401k plan. So this is one approach that an employer took, and the ruling is fairly limited to that one issue, but because they had to lay out their plan design, everyone was aware what the plan design was. So in that situation, if an employee makes a student loan payment and gets an employer contribution to the retirement plan, it's not a match. It's actually just the equivalent of an employer profit-sharing plan contribution, which means it's subject to the regular vesting rules, non-discrimination rules, not the 401k discrimination rules, because it's not really a 401k type of contribution. And for an employer, that could create an issue if a lot of lower paid employees elect to make the student loan payments. It could lower the contribution rate and affect the testing on the 401k side. So it remains to be seen, whether that would matter. And the other limitation about the letter ruling is that it is a private letter ruling, which means only the taxpayers that applied for it can rely on it. Other employers are not technically allowed to rely on it. So I wouldn't run out and necessarily add this to your plan. Most employers are going to be on prototype plans that don't have these provisions in any event. Let me go back because I want to talk about the Retirement Parity Act as well. So Congress, though, took notice of this private letter ruling, and there's bipartisan support for legislation to specifically allow employers to use student loan payments as a trigger for a match in a retirement plan. That's the Retirement Parity for Student Loans Act. And that act actually puts some more color around this. It defines what is a qualified higher education expense, attempts to answer the question of what does an employer need to do to, if you had this kind of program, to verify that payment was actually made on a student loan debt and what types of student loan debt would qualify. It would also extend the program to 403B plans and simple plans, which letter ruling only applies to 401k plans. There are still a few questions that are unanswered, probably a lot of questions that are unanswered, but look for this to be a continuing topic in 2019. There was also an act introduced into Congress to allow employers on a pre-tax basis to make student loan payments as an actual employee benefit. I don't think that's got as much support, but clearly this whole issue is on Congress's mind. All right, so moving on, the other topic that's fairly hot these days is cybersecurity for all of us, and particularly in my practice, cybersecurity for 401k plan administrators. Plan administrators have a duty to take reasonable steps to protect plan data. Now, there's an issue whether data held by an employee benefit plan is a plan asset or not a plan asset, but you can see even back in 2016, the ERISA Advisory Council was looking at this issue, thinking about this issue, and considering, what employee benefit plan administrators, what unique challenges they face in the cybersecurity space. Whenever we're talking about ERISA fiduciary potential liability, what a court looks at is process, not outcome. So it's entirely possible that you could have a plan data breach with no liability to the employer or the fiduciary because they followed a prudent process in dealing with cybersecurity issues. And I would suggest that the process would include education, so some self-education about the issue, some investigation about what is being done to protect plan data, both on the employer plan administrator side and on the vendor side, negotiation of any contracts. We review a lot of service agreements for employers, and one issue we always insist on having some provision in the contract would be reasonable steps to protect privacy and protect plan data. And then, of course, you want to document what you did. If you went through a prudent process, you want to be able to show that you did, and then continue to monitor for cybersecurity issues. So right now, we've got a number of plan administration committees who are bringing in education, training, creating internal controls, reviewing the agreements, and considering their cyber insurance needs. So often an employer will have cyber insurance, whether a plan or plan fiduciary needs to be specifically a named insured under that policy, make sure there's no exclusion for ERISA under those policies, and that the policy limits are adequate and protecting everyone. That's an issue to talk about with cyber insurance brokers and perhaps even in some cases counsel. And then we've got a little bit of a tension with the ERISA record retention rules. ERISA has a very long record retention requirement, which is, if you need to determine someone's benefit, you need to keep the records for however long is required to keep the benefit. In 401k plans where people have account balances, that may be less important, but certainly records of hours, records of addresses for participants, all of those things, ERISA has a requirement that the plan administrator maintain the records, whereas prudent data protection means you get rid of records as soon as you can. So that really has to be balanced. And then we have in California a new Consumer Privacy Act of 2018. That act is the strictest in the country. It'll apply to vendors. It'll apply to non-ERISA plans. It's not 100% clear whether it is preempted by ERISA and would apply to an ERISA plan. Preemption is probably, in my view, more likely than not. But some employee benefit plans are exempt from ERISA, stock plans, for example. Top hat plans may be IRA plans. So that's another thing that we will be watching, is how are the courts and California going to apply its Privacy Act to employee benefit plans. Then the third topic I wanted to talk about just our general financial wellness initiatives. Most employers are focused on this. We've got in this country both the student loan problems, and even though we've had an economic recovery, many people in this country still struggle to pay their bills, pay off their debt, do anything towards retirement planning. A study that I just recently saw said that 64% of employers say that this is an important initiative currently, with none really saying that it's not. And certainly anytime you've got employees who maybe are at retirement age but can't retire because they just can't afford to, it's not really in the employer's best interest to have them here hanging around. In that regard, the state of California also passed a law several years ago establishing mandatory retirement plans in California. That law is going into effect next year. It's in a beta test now. It's also the subject of litigation, but it would require, starting in 2020, any employer with 100 employees to have a retirement plan or join one of the state auto-enrolled IRA plans. Then in 2021, it would require employers with 50 or more employees to be in that plan. And then in 2022, any employer with 5 or more employees. So that's a very broad attempt at financial wellness in California. There is litigation over that plan, whether or not California can enforce it. But California has gotten an opinion from a law firm that they can, and they are moving forward regardless of the current legal challenges. Other things that are common would be budgeting and saving. Retirement is always number one on employers' mind, but budgeting for health expenses in retirement, budgeting for your home purchase, your college, those sorts of things are all in the financial wellness arena. Basic education about the stock market and how markets work and what is a mutual fund and what is the default investment, all of that falls a little bit under financial wellness as well. On the legal side, again, looking at service agreements and contracts for that sort of benefit. I raised cybersecurity again because some financial wellness initiatives are outside of the 401k plan, but you may be collecting either intentionally or unintentionally data about participants. You would need to think about any data collection, making sure you're compliant, particularly with the new California law. And then typically, although ERISA preempts state law, it doesn't preempt other federal laws. So the Americans with Disabilities Act, age discrimination, Title VII discrimination, which would be, for example, on the basis of race or sex, or HIPAA, which we've already known about. Those sorts of issues can get caught up in employee benefit plans. They're not preempted. So important to think about those as well. Doug, I don't know if you have anything that you wanted to add on the financial wellness initiatives. I know you all are probably very involved in that.
Yeah, no, I think you covered kind of the key areas of it, but yeah, us and our clients are getting more and more involved with the financial wellness. As you said, it's just becoming a bigger topic and hotter topic all over the country.
Right.
With the savings rates.
Right. I mean, my experience, retirement savings is number one, but also very high on it is disability insurance planning and life insurance planning. And with an aging population, a lot of baby boomers not necessarily leaving the workforce, that, you know, you've got these kinds of issues. So that wraps it up for me. I appreciate the chance to bring these to the forefront on folks' plate, and let me know if you have any questions.
Perfect. Well, I'll start off the question sharing. It's about cybersecurity, because I know that came up, with the financial wellness, and just you talked about it by itself. If I'm a plan sponsor, what is one thing I could do today to address some of my cybersecurity risks?
Well, I think the first thing to do would be to check your insurance, right? Check to see if you have any coverage, if anybody's given that any thought. The second thing I would do is look at your service agreements with your vendors and see if you've got any sort of cyber issues covered in those service agreements. Those would be the first two things I would want plan sponsors to be doing.
Got it. Perfect. And one question come in about, are there any limitations to the student loan ruling?
So the student loan ruling is very limited. It really only applies to that one situation. For example, that plan was not designed as a safe harbor plan. So it's not clear that you could set up a student loan payment arrangement in a safe harbor plan. Also, even if it's not a safe harbor plan and you're doing discrimination testing, it's not particularly clear how the testing will be done, because that was not addressed in the ruling. And then the piece that the proposed statutory change would fix is, what is the employer's duty? How do you know that they made a payment for a student loan? And does any student loan qualify? If you went to trade school, does that qualify? Does it have to be an accredited college? Do you have to have gotten a good degree? All of those sorts of down in the weeds issues, those are not really answered by this sort of limited letter ruling.
Sounds like a lot is still to be determined on some of those issues.
Yes.
Perfect. Well, that's going to bring us to a conclusion for our Beacon Pointe Fiduciary Point of View webinar. I'd like to thank Sherry Bowell for joining us this morning and sharing some of her valuable insights on key topics that plan sponsors can encounter in the coming year. This is Doug Eagle, the Director of Beacon Pointe's Retirement Plan Services, and thank you all for joining. If you'd like a copy of the presentation, or Sherry also had the white paper about negotiating plan service contracts, if you'd like either of those, you can reach us at bpawebinar@beaconpointe.com. Thanks again, and be on the lookout for the invite for our next Fiduciary Point of View webinar. Thanks, Sherry.
Thanks, Doug.